Yes. Good evening, everybody. I, Dr. Meenakshi Kalra, welcome you all on behalf of the Supreme Court Advocate on Record Association to this lecture series. Today, we've all gathered here for one of the important exams of leading cases in the upcoming AOR examination, wherein our esteemed speaker will enlighten us on right to privacy, registration of FIR, and circumstantial evidence. We have the honor to have with us today Senior Advocate Dr. Aman Hingorani, sir. We welcome you, sir, and we're thankful to you for taking out time and discussing the case of K.S. Puttuswamy, the landmark Aadhaar case, Lalita Kumari versus State of UP, Sharad Birdi Sarda versus State of Maharashtra, and Neeraj Datta versus State. We're showcasing this lecture live on YouTube. If anybody has any questions, the same may be put in the chat box and the same will be taken up by the end by sir. I now request our member executive, Reena Pandey ma'am, to please give an introduction about sir.
Good evening, everyone. It gives me immense pleasure and privilege to introduce Dr. Aman Hingorani, sir, a distinguished senior advocate at Supreme Court of India. Sir has been practicing law since 1992. He also serves as a mediator at Supreme Court and Delhi High Court mediation centers, and as an arbitrator with leading institutions, including the Delhi International Arbitration Center, PSDCCI Center, Indian Council for Arbitration, and IDRRMI, RMIT Australia, and among others in India and abroad. He is on Executive Council for NUSLR Ranchi and the Board of Mentors for the Executive Masters Program in Mediation at MNLU Mumbai. Sir is actively involved in legal education since 1998. Dr. Hingorani, sir, has taught law and conducted training programs for judges, lawyers, and faculty at premier Indian institutions such as National Judicial Academy Bhopal, State Judicial Academies, National Law Schools, Campus Law Center, Delhi University, and Indian Law Institute. Internationally, he has taught at Cable College, University of Oxford, University of Warwick, and South Indian Institute, Dhaka. An acclaimed trainer in advocacy and mediation, Sir was a faculty for SCAORA's first online mediation skill workshop in 2020. He has developed ADR curriculum for the All India Bar Examination, FICCI, PSDCCI mediation rules, and the British Council's Indo-British Advocacy Project. He also gave expert evidence on Mediation Bill 2021 before Rajya Sabha Parliamentary Committee. Many of his recommendations were incorporated into Mediation Act 2023. Sir is an author of Unraveling the Kashmir Knot, which presents the practical solution to the Kashmir conflict. He has spoken on Kashmir issues at national and global forums, including the UK Parliament. With over 85 publications, his work spans public interest litigations, Bhopal gas tragedies, mediation, intellectual property in GMOs, and global missile expansion. It's truly a privilege to have Dr. Aman Hingorani sir with us today for this lecture, and we look forward to benefiting from his deep knowledge and experience. Over to you, sir.
Well, thank you so much, Reena, for that very generous introduction. Good evening to everyone. And thank you, SCAORA, for giving this platform, Meenakshi, Nikhil, and the entire team for having me over today for this lecture. Now, I have been an AOR for many, many years. And I'm told this lecture series is meant for those who are taking the AOR exams. And so the approach of discussing today is more focused for the examinations as opposed to a broader jurisprudential exposition on the various principles involved in the cases which were mentioned earlier. Puttuswamy's case merits not a lecture of 1 hour, 2 hours, but of several days because it's a huge judgment. and that makes it very challenging for those who are going to take this exam. But so what I intend doing is I'll start off with perhaps the other three judgments, which is on registration of FIR and circumstantial evidence. And then whatever time we have left, I'll take you through the privacy judgment of 2017 and the Aadhaar judgment of 2019. So with that brief housekeeping rules, let's just get straight away into the judgments. The first judgment which we can discuss is Lalita Kumari, which was it's the landmark case on the issue of registration of FIR. The citation is 2014, Volume 2, SCC, page 1. It's a constitutional judgment. The bench is of 5 judges. There was a reference made by a judge or a bench of 2 judges. And the primary issue in this case is whether is a police officer bound to register FIR upon receiving any information relating to the commission of a cognizable offense under Section 154 of the erstwhile CRPC. Now, of course, we have the new law, similar provisions. Or can the police officer, does the police officer have the discretion or the latitude to first conduct a kind of a preliminary inquiry in order to test the credibility, the veracity of this information before registering the FIR? Now, the facts were very simple. It was a 32 petition filed by one Lalita Kumari, minor, through a father, Shri Bola Kamath, for a writ of habeas corpus. The daughter went missing, minor child. The police did not register the FIR. So the father went to the superintendent of police. Eventually, FIR was registered, but steps were not taken for finding where the child was, and so this petition of habeas corpus. Now, in this case, the Constitutional Bench had to, what the conflicting or the dilemma was, should somebody go to the police and say, this is the information, there's a commission of cognizant offenses committed, does the police, without at that stage going into the merits, into the credibility or the veracity of their allegations, straight away register FIR so as to reassure the victim that the case has been noted by the state? On the other hand, the minute you register the FIR, of course, from the accused's perspective, should any information be given, would that justify initiating the criminal process and have that person arrested without even an inquiry whether there's something in that particular information which has been given? So that was probably the dilemma or the conflicting areas of concern before the Constitution Bench. For those of you who are not familiar with Section 154, it basically says in simple words that every information relating to the commission of a cognizable offense, if it's given only to the SHO, shall be reduced to writing by him or under his direction. It will be read over to the informant, and it will be entered in the book. So the idea is the words used is any information, and it doesn't say credible information. It just says any information, and it says it shall be reduced in writing. So is this mandatory? Is it obligatory on the police officer that the minute any information which discloses or which relates to the commission of a cognizable offense is given, it has to be recorded? How do you construe this provision? 154 subclause 3 also talks about that if the SHO does not record this information, the substance of this information can be sent in writing by post to the superintendent of police, who, if satisfied that the information discloses commission of the cognizable offense, shall either investigate the case himself or direct for the investigation. But the point is, there is a remedy given should the police officer not register the FIR. 156 deals with the police power to Section 156 deals with the police power or police officer's power to investigate the cognizable offense. 157 talks about the procedure, and it contemplates that when information has been given and the police officer feels it appears to him that there's no sufficient ground for entering into the investigation, he shall not investigate the case. And of course, that notification must be given to the informant that the case is not going to be investigated. So it contemplates a closure report that despite information being given, there can be a situation where the police says no case is made out, we're closing this complaint or this information. Now, these are, without being exhaustive, these are some of the statutory provisions one must keep in mind to appreciate what was the argument. One line of argument was every police station has a case diary. Let the information come into the case diary. Let there be some kind of preliminary investigation. And then, if there's merit or it is the credible information, then let it be registered in the FIR as a FIR in the FIR book. So that was one of the contentions was raised that would satisfy the requirement of, but that would balance the rights of the victim, the informant on one side, and the accused on the other. So this case is important for the point of view that the Supreme Court explained, went into the legislative history and explained the difference between a general diary, which is also called the daily diary or the station diary on one side, and the FIR book, which is another document maintained at the police station. The general diary is not maintained under Section 154 of the CRPC. It is under the respective police acts. The police is a state subject, and they talked about having a kind of a general diary, case diary, which is supposed to record whatever happens in the police station. It's a general information when officers leave the station, come to the station, what transpired, etc. And so that was the purpose of that particular diary. Then later, when we had the CRPC of 1872, we talked about there being a police FIR book or a complaint had to be registered by the police, and for that there was a separate book. So there was a departure was made that a book was used in place of a diary, and that book was a FIR book. So according to the Supreme Court in this case, if we see the words of 154 that the information must be reduced in writing and that FIR must be registered, it has to be done in the FIR book. The substance of it can be summarized and put in the case diary or the general diary. But the FIR must be registered, a complete FIR must be registered in the book called the FIR book. So the case diary is not a substitute for the FIR book. These are two separate places where the information can be reduced, must be recorded in the general diary in form of the gist of the information, because that is something which happened in the police station, and the more detailed information in the FIR book. The FIR goes to the court, not the general diary. So there is a significance of that. The FIR would be numbered, the date and the number would be given, and that is what is meant, which will be sent to the court, so that there is also a question of supervision of the FIRs. The complainant's signature must be taken in the FIR book, but there is no requirement of taking a signature in the general diary. So there are the distinctions between the general diary and the FIR book. But what the Supreme Court said was it is not sufficient compliance that you just put the gist of the information in the general diary. The information must go in the FIR book maintained for that particular purpose. The Supreme Court also noticed that the language of Section 154, which I just pointed out, that any information is given, it shall be reduced in writing. It is not qualified by the words reasonable complaint, credible information, as we find in section 41, 1A and G of the code. That is where the idea is that whenever there is you want to arrest a person without a warrant, the complaint has to be reasonable. There has to be credible information. But these words, adjectives, are not mentioned in 154, and according to the court, there's no requirement at this stage for the police officer to be satisfied about the reasonableness or credibility of the information. It is not the reasonableness or credibility of the information is not a condition precedent to register the case. And the court, of course, went back into there was a legislative, the earlier courts, legislative history. Initially, in the 1861 code, the requirement was complaint or information. Subsequently, it was modified in the 1872 code to say a complaint. Then, subsequently, the word complaint has been replaced with the word information in 1882 and 1898. So, in the different codes, the language has changed. Earlier, it was from complaint information to complaint. Now, it is information, and it's only information. So, in view of that, the court said on the plain reading of section 154, the minute any information relating to a cognizable offense is given, then the police officer shall, it's mandatory, he has to record it, has to register the FIR. And according to the Supreme Court, there are compelling reasons for this. It sets the criminal process into motion. Nobody can then later on improve upon it. Nobody can try to make a case better because of the delay. It also checks the powers of the police, because each time something happens and is documented, the police gets tied down by what has been documented. So everything should be written and documented at the earliest point of time. It brings about transparency. And of course, as we all know, all this is under judicial oversight. You need to have something, a document that goes for the in form of a report before the magistrate. So, according to the Supreme Court, there are advantages of having reading an obligation or saying there's the obligation on the police to straightaway register the FIR. It's a first step of access of justice to the victim. It upholds the rule of law. It facilitates swift investigation, can even prevent crime, and there's less chance of manipulation in criminal cases. So we don't have anti-dated FIRs or delayed FIRs. But on the other side, what about misuse? The dilemma which was there, if there's a FIR and an arrest, then even if it's an innocent person, it's a fanciful allegation, the reputation of that person goes if he's arrested. And there could be arbitrary arrest, and that would violate Article 21. So the Supreme Court took the view that registration of a FIR does not necessarily mean arrest. As we have talked about the procedures, 157 also contemplates closure. The provisions I read out or was mentioned talk about the police officer not being bound to investigate where he feels no case is made out, or informing the informant that the case has not been investigated. So registration of FIR cannot be equated to the immediate arrest of the accused. And so there are safeguards with judicial oversight, etc., to see there's no arbitrary arrest. And of course, there's a provision of anticipatory bail. So given the fact that the code gives the police the power to close a matter both before or after investigation, that itself shows that it's not necessarily the police will arrest somebody just because the FIR is registered. So, in view of that, the court took the view that it is mandatory for the police to register the FIR immediately if the information given relates to the commission of a cognizable offense. At this stage, we do not see the reasonableness, the veracity, the credibility of the information. That's the subject matter of investigation. Having said that, the court also referred to earlier precedents which had created some exceptions. For example, cases relating to medical negligence by doctors. And the court in earlier precedents has said it would be unfair to prosecute a doctor, a medical professional, only on the basis of the complaint, or only on the basis of the allegations made in a complaint. So normally the court, in the earlier cases, there was that you should have another opinion of another doctor, whether there was error of judgment or a criminal negligence or so on and so forth. So the court did acknowledge that there can be exceptions. In the previous precedents have talked about exceptions. But the court took the view that, and so the court in this case also carved out what could be, without being exhaustive, what could be some of the exceptions. But the purpose of the preliminary inquiry, what's important to note, according to the Supreme Court, is not to delay the registration of the FIR till the police goes around trying to collect evidence, etc. The purpose of the preliminary inquiry is only to ensure that is a cognizable offense, has it been made or not? So that if it is in this backdrop, if I quickly just go, since we I don't want to spend too much time on any one particular case, the conclusions or the directions given by the Supreme Court in Lalita Kumari's case are restoration of the FIR's mandate to under Section 154 of the Code if the information discloses commission of a cognizable offense, and no preliminary inquiry is permissible in such a situation. If the information received does not disclose a cognizable offense, but indicates a necessity for inquiry, a preliminary inquiry may be conducted only to ascertain whether the cognizable offense is disclosed or not. If the inquiry discloses the commission of a cognizable offense, the FIR must be registered. In cases where preliminary inquiry ends in closing the complaint, a copy of the entry of disclosure must be supplied to the first informant forthwith and not later than 1 week. It must disclose reasons in brief for closing the complaint and not proceeding further. The police officer cannot avoid his duty of registering offense if cognizable offense is disclosed. Action must be taken against erring officers who do not register the FIR if information received by him disclose a cognizable offense. The scope of the preliminary inquiry is not to verify the veracity or otherwise of the information received, but only to ascertain whether the information reveals any cognizable offense. As to what type and which cases preliminary inquiries to be conducted will depend on the facts and circumstances. Some categories the court indicated: matrimonial disputes, family disputes, commercial offences, medical negligence cases, corruption cases, cases where there is abnormal delay or latches in initiating criminal prosecution. So, if you have a delay of say 3 months without giving any reason for the delay, why a person has come late to report that particular offense, the court says in these kind of cases might warrant preliminary investigation, preliminary inquiry. While ensuring and protecting the rights of the accused and the complainant, a preliminary inquiry should be made time bound and it should not exceed 7 days. The fact of such delay and causes of it must be reflected in the general diary entry. Since the general diary, station diary, daily diary is a record of all information received in police station, all information relating to cognizable offences, whether resulting in registration of FIR or leading to inquiry, must be mandatorily and meticulously reflected in the said diary. And the decision to conduct the preliminary inquiry must also be reflected. So this is broadly the sum and substance of Lalita Kumari. To conclude, it is mandatory to register the FIR immediately on receipt of information, that is, any information relating to the commission of a cognizable offense. Should it not be clear from the allegation whether there is a cognizable offense committed or not, then you can have a preliminary inquiry to to ascertain that, not the veracity or the credibility, etc. And of course, the court has noted the exceptions to this particular proposition also, that there are certain kind of cases where it might be more appropriate to have a preliminary inquiry. So this was Lalita Kumari's case. In line of these cases, the other issue is also about circumstantial evidence, particularly when you base a criminal conviction on circumstantial evidence. Two cases have been indicated. One is Sharad Pirti Chand Sarda versus State of Maharashtra. Citation is 1984, 4 SCC 116. And the other case is Neeraj Datta versus State, the citation of which there are several decisions relating to this. The one indicated in the course material or the for the year exam is 2023 4 SCC 731. Now, Sharda Birdi Chand Sarda's case basically talked about when can you base a conviction on on when there's no direct evidence. What are the criteria on which a conviction can be based using circumstantial evidence? The facts are pretty straightforward. There was a marriage between Manju and her husband, but she was disappointed in that marriage. Within nearly about 4 months of the marriage, she was found dead in her bed. According to the prosecution, she was murdered by the husband who was having an affair with another lady, and he had administered potassium cyanide to Manju. According to the defense, that yes, it was a bad marriage, but Manju had committed suicide by consuming potassium cyanide. So the issue was that was this a murder or a suicide? And the Supreme Court, the courts below had convicted, that court's trial court and the High Court had convicted the appellant on the ground of that the case is made out based on circumstantial evidence. Now, in this case, the Supreme Court reiterated the law regarding the nature and character of proof of circumstantial evidence. And the classical case, the landmark case, is Hanumant versus State of Maharashtra, State of Madhya Pradesh, I'm sorry, 1953 SCR 1091. That's 1953 SCR 1091, where there were supposed to be 5 conditions that must be satisfied before invoking circumstantial evidence to sustain a conviction. The first was the circumstances from which the conclusion of the guilt is to be drawn should be fully established. The second was the facts so established should be consistent with the hypothesis of guilt and the accused, that is to say, they should not be explainable on any other hypothesis except the accused is guilty. The third was the circumstances should be of a conclusive nature and tendency. The fourth was they should exclude every possible hypothesis except the one to be proved. And the fifth, which is very important, there must be a chain of evidence so complete as not to leave any reasonable doubt for the conclusion consistent with the innocence of the accused, and must show that in all human probability, the act must have been done by the accused. So, according to the Supreme Court, these are the 5 golden principles laid down in Hanuman's case, and the Supreme Court reiterated these principles, also referred to precedents where these principles had been followed. In this given particular case, there were letters which had been written to by the deceased, which were connected or related to a death, which disclosed what happened in the marriage, the bad marriage. And so there was also a whole discussion on Section 32 of the Evidence Act, on whether it's a dying declaration, because these letters were written sometime prior to the death. So whether the distance in time would alone would make the statements irrelevant. And in that case, according to the court, we won't really get much into this because of shortage of time, and that's not what the case is all about when we talk about circumstantial evidence. But the court did go into Section 32 to say there could be a series of incidents, a series of statements talking which the deceased might have given over a period of time. There could be a whole drama going on which unfolds ultimately in the death of the deceased. So merely because statements have been made over a period of time, that does not make them irrelevant under the Evidence Act. So that is, if anybody is interested in the case law on Section 32 on time declarations, this is the decision also for that proposition. But on the findings, the court found that the letters did show a sense of frustration. It is possible that she may have committed suicide. We can't exclude the possibility of suicide because she was disturbed, she was impressionable, she was very emotional, she was desperate, and so she could have committed suicide. But that is not enough. You have to exclude the possibility. This is only a possibility. The hypothesis has to be one that you have to say that the only person who could have done this is the accused. And for that, according to the Supreme Court, in this particular case, on facts, the court found that there were many chains of events, there were many incidents by one, but one of the essential ingredient of the case of death or by administration of poison, that is potassium cyanide, that there should be some evidence that the accused had the possession of that poison, of the poisonous material. In this particular case, the court found on facts that there was no direct evidence, no circumstantial evidence, no evidence whatsoever of any kind to show that the accused had in his possession this poison. And according to the Supreme Court, it the evidence does not justify the irresistible inference that only the accused could have done it. This particular link, one chain is missing. And so it is for that reason that the accused would have to be given a benefit of doubt. An interesting argument had been raised in this case by the state, which had found favor with the High Court. That is that the accused had given some false explanations. And according to the High Court, the falsity of the explanations given by the accused filled in whatever lacuna or the missing links. And that, according to Supreme Court, is a wrong proposition of law. According to the Supreme Court, the prosecution must stand on its own legs. The chain must be established by the prosecution either by direct or circumstantial evidence. Should an accused have given a false statement, that is only an additional link, that's only an additional assurance to the court that yes, he is guilty. But a false explanation cannot fill in the lacuna in that chain. That chain must be complete by itself, and that the prosecution has to establish either by direct or circumstantial evidence. So even in a case, so in a given case where the prosecution, the circumstantial evidence is not to that degree, or there are some links are missing, you cannot take assistance from a false explanation by the accused to fill in that lacuna. So, according to the Supreme Court, this was one of the lacunas which vitiated a fatal infirmity, wrong application of law, the wrong law which has been applied by the High Court, which entitled the accused to benefit of doubt. It might be that he has murdered her, but when two views are reasonably possible, the benefit must go to the accused. So this is the sum and substance of this particular judgment of the Supreme Court in Sharad Birdi's case, where the court reiterated the five golden rules that if you can sustain a conviction on circumstantial evidence, but the circumstantial evidence must be of such a degree that no other possible conclusion has to be there. It must be conclusively established that the accused and only the accused has committed that offense. And even if one link is missing, then you can't sustain a conviction. There's a possibility of two views. Mere suspicion cannot be a substitute for proof. The prosecution has to establish conclusively through that chain of events that the accused and only the accused could have caused that particular offense. Later decision on this particular case is of that of Neeraj Datta's case. That is, I'll just give you a citation. This is a constitutional decision. Again, the reference was made by two judges. This was in context of the Prevention of Corruption Act. Facts were again straightforward. The complainant was doing a business of sale and purchase of cars in Vikaspur in Delhi. He wanted a luxury meter. His meter was not there, so he got a meter put that was removed. And then he got a call from the accused lady who says she was working as an inspector in the electricity department in the local area. And she called him to her residence, come in, let's discuss this matter. And then she demanded a sum of rupees 15,000 as bribe to get the meter installed. There was negotiations. She ultimately agreed to 10,000 rupees and she was to come to collect the money. A trap was laid for her, and so on and so forth. But however, before the matter went to trial, the complainant died. So there's no direct evidence of a demand. So the question which was referred to the by two judges to the Supreme Court is whether in absence of evidence of the complainant, direct or primary evidence of demand of illegal gratification, is it not permissible to draw inferential deduction of culpability or guilt of a public servant under Section 7 and Section 13(1) clause D, read with Section 13(2) of Prevention of Corruption Act based on other evidence adduced by the prosecution? So basically, it was complainant has died. There's no direct evidence. There's no primary evidence of a demand. Can we use circumstantial evidence? Inferential deduction means circumstantial evidence to establish the guilt of the public servant based on the other evidence adduced by the prosecution. So that was the question before the Supreme Court. The court, of course, has gone into the provisions of the Prevention of Corruption Act, which we don't really need to get into today. Section 7, Section 13, Section 20 presumptions, etc. The observations which are relevant, this is constitutional decisions, the observations which are relevant in context of circumstantial evidence is that circumstantial evidence does not establish the fact in issue directly. It means facts from which another fact is inferred. So, but though circumstantial evidence does not go to prove directly the fact in issue, it is equally direct. Circumstantial evidence also has to prove by direct evidence of the circumstances. So the court talked about the degree of proof. It is indirect evidence, whether by means of witnesses, things, or documents, but this must be also proved conclusively before you go and sustain a conviction on it. According to the Supreme Court, circumstantial evidence is evidence of circumstances as opposed to what is called direct evidence. The prosecution must take place and prove all necessary circumstances constituting a complete chain without a snap and pointing to the hypothesis that except the accused, no one had committed the offense. The court did give a note of caution that a cautious approach should be based while basing a conviction purely on circumstantial evidence. It's only when all the incriminatory facts and circumstances are found to be incompatible with the innocence of the accused, then you can perhaps do so. So, according to the Supreme Court, again, there's a reference about if the chain is complete and the accused gives a wrong statement or false defense, then that becomes an additional link. So accused gives no explanation or offers explanation which is found to be untrue. The same becomes an additional link in the change of circumstances. And so, according to the court, even if there is no direct evidence, but there is adequate or proper circumstantial evidence to establish proof of demand, acceptance, or legal gratification, then the prosecution can continue. It does not abate simply because the complainant has died. So, according to the findings in this particular case, is that the proof of demand, acceptance of illegal gratification by a public servant as a fact in issue by prosecution is sine qua non in order to establish the guilt of the accused under this act. It can be, this must be proof, but this proof of demand and acceptance of illegal gratification can also be proved by circumstantial evidence in the absence of direct oral or and documentary evidence. The presumption of fact with regard to the demand, acceptance, or obtainment of illegal gratification may be made by court of law by way of inference only when the foundational facts have been proved by relevant oral and documentary evidence and not in the absence thereof. And in the event the complainant has died, is not available, then this demand of illegal gratification can be proved by letting in evidence of any other witness who can again let in evidence either orally or by documentary evidence, or the prosecution can prove the case by circumstantial evidence. The trial does not abate, nor does it result in order of acquittal of the accused public servant. And so, accordingly, the court, the constitutional bench answered the reference by simply saying that in the absence of the evidence of the complainant, it is permissible to draw an inferential deduction. It is permissible to rely on circumstantial evidence of proof of culpability or guilt of the public servant. So this was the second case on circumstantial evidence. So we have discussed very briefly Lalita Kumari, Sharda, Neeraj Datta's case. Now let's get into the topic of right to privacy, as I'm also keeping a track of the time. Given the fact it's already 5:43, when it comes to the privacy judgment, it's a huge judgment, 9 judges. It basically came along because when the Supreme Court was set up, the initial judgments, A.K. Gopalan, in 1950, those judgments had a very different approach towards fundamental rights, which that construed each provision in Part 3 as embodying a distinct protection. The 11 judge bench in R.C. Cooper's case in 1970 said that's not good law. There's a common thread that runs in fundamental rights and the trinity of rights, Article 14, 19, 21, and so on and so forth. But based on the earlier judgments of A.K. Gopalan, the Supreme Court had um, had referred to two earlier other decisions, MP Sharma's case, 8 judges, 1954, Kharak Singh's case, 1963, 6 judges, and these judgments had brought into doubt the question that do we have a right of privacy as a fundamental right in Part 3? Because it's not expressly there. Can you have a fundamental right of privacy? So, according to MP Sharma, Kharak Singh, according to them, right of privacy was not elevated to a fundamental right. And so, but since these judgments of MP Sharma and Kharak Singh, so based on Gopalan's case, and Gopalan's case was itself overruled later on in R.C. Cooper's case, the Constitutional Bench was set up to conclusively talk about is right to privacy a fundamental right. So it is in that background that we get into this discussion. And according to the Supreme Court, reading the preamble, the Part 3 in particular, Article 21, 19, 14, the preamble, according to Supreme Court, it is an intrinsic part of Article 21 and the freedoms guaranteed in Part 3. So there is a fundamental right of privacy, which is part of Article 21. The importance of this case is that not only does it read as part of Article 21, according to the Supreme Court, to put it very simplistically, you need to be in a zone of privacy to be able to have a free choice to be able to exercise any or all other fundamental rights. So it's a core fundamental right. It goes to the core of the matter. In the absence of the zone of privacy, a person may not be able to exercise the other fundamental rights, whether in Article 14, whether it's the religious rights, whether it's minority rights, whether it's Article 19 rights. It is so deeply entrenched, according to the Supreme Court, right of privacy is so deeply entrenched in the Constitution Part 3 that it actually gives this place or the space for a person to exercise other fundamental rights. So, according to the Supreme Court, right of privacy is a natural, primordial, basic, inherent, inalienable rights. It permeates the core of the preambular philosophy of liberty and dignity, the human concepts of life and personal liberty. It finds recognition in various international conventions, Protection of Human Rights Act of 1993. So, simply because it's not been expressly provided doesn't mean that it's not there. It is omnipresent. It just permeates every fundamental right, which is there in Part 3. It has many connotations: spatial, decisional, informational. It has it has physical and mental aspects. It is so simply you can't say because it's vague or it's omnipresent, that's why it does not exist or we won't recognize it. So according to the Supreme Court, the Constitution puts the individual at the forefront of its focus, guaranteeing civil political rights in Part 3. You have the aspirations or the directive principle of state policy for the socioeconomic rights in Part 4. For the individual to even be able to realize these rights, you must have a fundamental right of privacy. So that is the importance which the court has given to right of privacy, saying it's a core fundamental right. The court also went on to say that it's not an elitist construct. Uh, Everybody, regardless of the stature or the status of society, whether it's poor or rich, each one of them have a uh, right to fundamental right of privacy. It is not merely a common law right; it is a constitutional right. And so, if a state violates the fundamental right to privacy, then a writ will lie. If a non-state violates it, then you would have your remedy under the common law. They both, the right of privacy is both a common law right and a fundamental right. The court also talked about the importance of fundamental rights in context of a plural society, a diverse society, for the importance of conservation, cultural, education rights. The court emphasized that the right attaches to the person, not to the place. So a person may be in a public place, but can still be whispering and maintaining the right of privacy. So the place is not important. It is an individual which has the right of privacy. It gets attached to to the person. Now, when we talk about the protection of this fundamental right, because this becomes more and more important when we talk about the Aadhaar judgment, when we talk about informational technological privacy, the internet, when you're collecting data in the on the net itself, social media networks, profiling, uh, is it surveillance by the state, etc.? What kind of control there can be put on this dissemination of information? Does the control remain with the individual, or can the state intervene for legitimate state interest, and so on and so forth? All those aspects were discussed in this case, but then further discussed in the Aadhaar case, which we will just come to. So, according to the Supreme Court, the right of privacy would include rights to privacy in the cyberspace, internet, social media, the right of identity, right to control dissemination of personal information, right to be forgotten, privacy of children. When we talk about information technology, according to the Supreme Court, there are three facets. One is non-information is non-rivalrous, because they can be simultaneous users of the piece of information. It is information invisible because it's very difficult to detect. Information can be accessed, stored, disseminated without being noticed. The ability to travel very fast at the speed of light enhances this invisibility, and the information is recombinant. In other words, the data output can be used as an input to generate more data output. So, there, according to the Supreme Court, there are different layers of information when we're talking about information technology and the internet. And then the court then goes on to discuss about the restrictions on this right. While you have a fundamental right of privacy, it's not an absolute right. What are the permissible restrictions which can be there? And now, if we were to say right of privacy is only in Article 19, then we say the limitations in 19.2 would apply. But Supreme Court said private privacy flows from every fundamental right. So you would have to see what is the nature of invasion of privacy. If it's in context of Article 21, it is the standard would be the procedure should be fair, just, and reasonable. If it is 9, it has got to be in context of 14. Then you have to see that the procedure should not be arbitrary. If it's in context of Article 19, then the requirements of 19.2 kick in. So you would have to see this on the facts and circumstances of each case. What are the restriction limitations made by the state to protect legitimate state interest or public interest so as to justify that invasion of the right to privacy or the regulation of that right to privacy? So the court went on to then explore. There's a huge amount of discussions as to what are the standards of compelling public interest and so on and so forth. There has to be a legislation, there has to be a need, there has to be proportionality. According to the Supreme Court, when we talk about invasion of life or personal liberty and the privacy must meet the threefold requirements of legality, which postulates the existence of a law; need, which is defined in terms of the legitimate state aim; proportionality, which ensures a rational nexus between the objects and the means adopted to achieve them. This is important because this is the test reiterated in the Aadhaar judgment, whether the Aadhaar law satisfies these three requirements, with the majority in Aadhaar's case saying it does, and the dissenting opinion says it does not. Legality, that is Aadhaar law, there is Aadhaar law; the need, whether there's legitimate state aim, and whether there's a rational nexus between the object and the means adopted to achieve them, that's a proportionality test. According to the majority judgment, these requirements are satisfied. The dissenting judgment says no, and we'll just come to that when we talk about uh, Aadhaar judgment. Or actually, we should move to the Aadhaar judgment. It's already 5:54. But I've just given you a very brief overview of what Putttaswamy's case is. It's a very lengthy judgment, several judgments, concurring judgments. Many judges have differed on the nuances or different aspects. So it's just impossible to summarize that in a span of 5, 10 minutes or 15 minutes. So you would probably have to go through at least all the head notes to go through it. But this is just to set the background as to where we started from, that there is no fundamental right of privacy, to say it is a core fundamental rights on the basis of which a person exercises other fundamental rights which have been enumerated in Part 3 of the Constitution. Quickly moving on to the last judgment, which is the Aadhaar judgment, um, where we had three judgments actually. This is a constitutional decision, 5 judges. You had Justice Sikri giving judgments on behalf of Justice the CGM, Justice Mishra, and Justice Kanwalkar. And then you have Justice Shokujan giving a concurring judgment, slightly more conservative, but concurring with the majority. And then you had Justice Chanchur giving a dissenting opinion. Now, if we very quickly go into this, the majority upheld the constitutional validity of the Aadhaar Act. while striking few provisions as being unconstitutional. So, according to the Supreme Court, Art Section 7, which makes Aadhaar mandatory for availing state subsidies, is valid. On the question of privacy, according to the majority judgment, the Aadhaar does not create a surveillance state because there's a minimal possible of data, demographic or biometric, which is being collected. So the amount of data is relevant. And further, according to the majority judgment, there are enough safeguards to protect the data of the Aadhaar holders, such as encryption and time limits on storage. According to the majority judgment, Aadhaar is unique and more foolproof because it's based on biometric information. It cannot be duplicated. And it is, according to majority judgment, this is an empowering tool to facilitate disposal of state subsidies and benefits to the marginalized. There is a fundamental right of development according to the judgment. A right of development is also a fundamental right under Article 21. So, according to the Supreme Court, the Aadhaar judgment does not violate right of privacy because it passes the threefold test, which I just mentioned about the there has to be a law, the need, and the proportionality. And according to the majority judgment, the standard review to test privacy infringements, that is, the law has to be fair, just, and reasonable, is also been satisfied in this particular case. According to the majority judgment, Aadhaar, on the other hand, will actually go towards protecting the fundamental right of right to dignity, which is implicit in Article 21. It will help the disadvantaged sections to lead a dignified life by getting them subsidies, state benefits, effective realization of the socio-economic rights. And so, according to the Supreme Court, this judgment is towards protecting fundamental rights. There were few provisions which were struck down, of course. Section 2D was struck down, saying that you can't collect metadata which is conducive to surveillance state. You cannot make mandatory Aadhaar mandatory for CBSE, NEET, UGC, but they're not service or benefits by the state. You cannot make Aadhaar mandatory for children of elementary education, but that's not a benefit, that's entitlement. Uh, Section 33(1) was read down. 33(1) of the Aadhaar Act prohibited disclosure of Aadhaar information except by order of a court. That was read down to say individual can can appeal to have disclosure of the Aadhaar information. Section 33(2), which allowed for disclosure of Aadhaar information in interest of national security, was struck down. Section 47, which allows for cognizance of an offence only when the UIDAI authority or any authorized person makes a complaint, was partially struck down. There was a recommendation that the individual can file the complaint. Regulation 27 of the 2016 regulations, which said you can retain data of 5 years, that was struck down. According to the court, data majority, the data should not be there for more than 6 months. Uh, According to the court, Aadhaar and PAN linking is valid, but not the Aadhaar and bank or SIM linking, because that does not meet the proportionality test, does not have legislative backing, and so on and so forth. Justice Bhushan gave a concurring judgment, slightly more conservative. He upheld more provisions than the majority judgment, and also he also was quite this judgment is also quite detailed in context of whether Aadhaar is a money bill under Article 110 of the Constitution. A money bill, a bill which talks only about the elements in Article 110 relating to the Consolidated Fund of India. Uh, Only those bills do not need to go to Rajya Sabha. So if it's a money bill, the implication is if it's a money bill under Article 110 of the Constitution, the Aadhaar Act does not go to Rajya Sabha. On the other hand, if it's not a money bill, then you would need to go to Rajya Sabha. So according to Justice Bhushan's judgment, where he detailed the reasons why he feels that Parliament was competent to pass Aadhaar Act only as a money bill. So, and of course, the dissenting judgment completely disagrees with this, particularly the money bill. According to the dissenting opinion, the entire act, the rules, regulations are unconstitutional. The Aadhaar Act could not have been passed as a money bill, and you have actually debased the Rajya Sabha, taken away that protection to check Lok Sabha. And the article 110 talks about a bill, money bill talks only in terms for the what is meant in Article 110. The word uses only, but the Aadhaar Act talks about privacy, dignity, talks about the development, state subsidies, etc., socioeconomic rights. So it's not only a money bill. So, according to the dissenting judgments, the Aadhaar Act governs several other aspects relating to Aadhaar scheme, none of which lies in the scope of Article 110, Clause 1. Nor does the Aadhaar card declare expenditure to be incurred by the Consolidated Fund of India. It basically says that if you want to take money from the Consolidated Fund of India, then the beneficiary must have, is mandatory for them to have the Aadhaar. So it's not quite the same thing as saying that this particular Aadhaar Act deals with or expenditure to be incurred by the Consolidated Fund of India. So according to the dissenting judgment, this was this law was not introduced as a money bill. It was not a money bill, and so it could not have been passed as a money bill. The dissenting judgment also has its own views on the issue of right of privacy, on the whether all the triple test in Puttaswamy's case was satisfied, saying it was not, whether this amount of state surveillance, etc. There was, according to the dissenting judgment, the if his biometric system is compromised forever. There are certain perils, certain kind of safeguards which need to be put out there. There is the individuals must be given a right to access, to correct, delete the data at any point of time. There should be a procedure which is opt-out option. The Aadhaar Act and the regulations framed are silent on the question of informed consent. They do not provide for procedure through which the individual can access information, and so on and so forth. So, according to the dissenting judgment, the Aadhaar framework does not address privacy concerns, and so it is violation. It is violative of informational privacy. Uh, the court went to different provisions of the Aadhaar Act to explain why each of these provisions are arbitrary or they violate basically testing on the stone of privacy laid down in Puttaswamy's case, the privacy judgment, why this particular act is completely unconstitutional. So this is very briefly, sorry, 5 past 6, so I think I'll stop here. But this is very briefly an overview of the two judgments, Puttaswamy judgments, one on the constitutional right, fundamental right of privacy as being a core fundamental right, and the other on the Aadhaar card, majority saying it does not violate this right, dissenting opinion says it does violate this right. Any questions? I can take them now.
Thank you so much, sir, for such an enlightening and comprehensive lecture. I myself cleared a lot of concepts which I had a doubt with. So we have a few questions, sir. The first question is being asked by Rajesh Kumar, and he says that, sir, is there a conflict between the Lalita Kumari judgment and the Arnish Kumar judgment or the registration of FIR?
Which is the other judgment?
It's Lalita Kumari.
The other, no, which is the other? Your voice is not very clear. Which other judgment?
Arnish Kumar, sir.
No, I don't see a conflict. By in what sense does he say a conflict?
He only says about FIR registration.
No. You see, the only place where I found Lalita Kumari could have been slightly more clearer because on one side they talk about exceptions, where they talk about, where they can be preliminary inquiry, etc. And they give them the scope, and also in context of in the CBI manual, they say later on, of course, they say in the CBI manual is a state that's under the Delhi, it's a Delhi Act, where CBI was set up, and that expressly provides for preliminary investigation before proceeding. At one place, the judgment in the conclusions very clear, which says there's no question of preliminary investigation when there is a commission of when the information discloses commission of a cognizable offence. So there's no question of preliminary investigation. But then it also lists down later on the preliminary inquiries exceptions, where they say in these matters they can be preliminary investigation. So that has led to certain kind of interpretations and different judgments. But I would like to know what kind of conflict he's talking about. If not, then we quickly move on to the next question. It's already
Yeah, no, sir. So
yeah.
the second question is by SRV. He's asked that, sir, could you please guide on the Panchsheel test laid down in the Sharad Bindri Chandra case, as there are 5 tests? Are the 5?
These the 5 principles I read out are the Panchsheel test.
Yes.
The 5 principles which was done in Hanuman case, that is what the Supreme Court says these are the Panchsheel.
Okay, very well, sir. And the third question is by Abhimanyu Yadav, sir. And he's asked that, sir, can you point out the difference between two Puttaswamy judgments or the gradual flow from the first to the second?
You see, Puttaswamy judgment is, like I said, is a huge judgment where you have multiple several judgments being given, and there are certain nuances when we talk about a standard review, strict scrutiny, or whether it is fair, just, and reasonable under Article 21 or so on. So we talk about. Uh, so it's a question of degree how the different judges dealt with it. Now, what happened in Aadhaar judgment, the Supreme Court, from all the different views, says we are preferring the proportionality test. So they've narrowed it down, or rather, they've crystallized it more. It's not that they've said from all these views, the ones which we are preferring is the proportionality test. There should be a law, there should be the need, there should be proportionality, and we are adopting, which is also done in Puttaswamy privacy judgment, that it's not a strict scrutiny test. The standard under Article 21 would be that the law should be fair, just, and reasonable. So what has happened, according to me, it's not as though there's been any change of law, but there were multiple voices in those various judgments in Puttaswamy privacy judgment that has been from those the ones which the Supreme Court has identified which ones they're following in the Aadhaar judgment.
Right.
So that has been it's been more fine tuned, is what I would say.
Okay, sir. The last question is by Sudesh Desai, and he's asked that, sir, is there a requirement to moderate right to privacy in view of the stark realities necessitating the continued governmental control and access to ensure national security concerns?
Well, that's something which is not strictly that goes beyond the thing.
Yeah,
But yeah, I
right.
mean, there is a debate as to whether this is a Big Brother thing, whether you have this slowly, it's a slippery slope. Once you start giving access, now you see when you're with your you go to the airport, you would have this you need.
Yeah, sir.
Yeah, so slowly, one and more facilities. Now they are at one level, the facilities. It
Right.
makes life easier, but at the same time, you're also giving away all your details. But
Hmm.
then, to as a counter of that, now you can mask your Aadhaar card. So that
Right.
is yet another safeguard. So this is a perennial debate whether you would go Digi Yatra way and try to talk about facilities, etc., and mask, or you would say that you're giving too much data in the hand of the government, which eventually may get leaked or may be given to a private player. So a person the focus of Puttaswamy privacy judgment was that the individual in the forefront. Everything should be done. What part three is to protect the fundamental rights of the individual from the being invaded by the state, and so the individual must at all times have the complete control about themselves, their personhood, their identity, their preferences, their choices. They need to have a zone which is free from societal judgment. They can, in that zone, deviate from social norms because that's the zone of privacy, and that is when they can choose what fundamental right to exercise and how to exercise it. So
Hmm.
that's spatial, this and all the different kind of facets of privacy. Aadhaar judgment would dilute it from the point of view of saying, well, there's the state interest, etc., socioeconomic rights, even the poor and the rich are equally entitled to all fundamental rights, and they're supplementary, complementary to each other, socioeconomic rights and civil political rights. So why should, if there is a larger public interest, then the individuals would they get restrictions on the individual rights are justified. So it is diluting that particular right. Now, when we're having safeguards, what kind of safeguards can you have to ensure that is mere regulation, it is not encroachment? So that debate is ongoing.
Right, sir. And the last question by SCAORA is see that will you be able to share your notes for today's lecture?
There are no notes.
Okay.
So basically, what I have done is very quickly gone through the head notes from Putuswamy, etc., from there itself,
But see, it
and
was an
and,
extempore
and
lecture. It was just
but the other three judgments, I was seeing the head notes. I did not find the head notes capturing what was inside the judgment. So that's why it's better to, those judgments are not very long. It's maybe better to read the judgments. You'll read and parts of it, of course, are on facts, which you can skip because one does not really analyze. I mean, we can simply say on facts, the court found this. So if we exclude the factual matrix, the legal propositions are not many and it can be quickly summarized.
okay, sir. I'll just conclude the lecture with a vote of thanks. I, on behalf of the Supreme Court Advocate on Record Association Executive Committee, I extend a heartfelt gratitude to you, sir, for delivering an insightful lecture on important topics of criminal law and also right to privacy for the leading case exam as a part of the SCORA AOR lecture series. Your expertise in highlighting the key principles have been invaluable. Sir, your in-depth analysis of professional uh, parameters such as will undoubtedly benefit the AOR aspirants, providing them a first-hand understanding of the importance of upholding the ethical standards. We appreciate your presence, sir, and we look forward to having you up on board again for the future AOR lecture series. Thank you to everyone who's attended this lecture, and we wish everyone the best of luck for their future AOR examination. Thank you so much, sir.
Thank you.